10th, 2026. We will begin with the appeals calendar, new cases, item number 6.
Tony, we can't hear you.
Again.
Tony, sorry. We can't hear you at all.
My apologies, we'll reset. Good afternoon, everyone.
Is the room on?
Yes, Ms. Matthias,
You
we're
can hear me
live.
now?
Yes, you may proceed now.
Thank you, Ms. Brenda. Thank you, Mr. Costanza. Good afternoon. This is the New York City Board of Standards and Appeals public hearing for August 10th, 2026. Please be advised that, we'll start with the appeals calendar, new cases, item number 6, 2025, 54A, 2114 Coyle Street, Brooklyn. Please note for the record that Commissioner Otley Brown is joining us remotely. Just one second. If DOB's team members want to join, please raise your hand now so that we can have you in the room. Megan, James Schmidt, okay. Whoever is this, your parties? The appellants? Members from the appellant?
Can I share my screen? Yes. Are you joining the Zoom? If you can raise your hand in the Zoom. You have a part of it as well? Okay.
He's part of your team?
Or part of the team? He's part of it. Okay. Just make the statement that the public will have an opportunity to speak at the closing of the presentation.
Members of the public will have an opportunity to speak at the end of this presentation.
OK，喺呢個展示之後咧，咁大眾咧，大家咧大家就會有機會可以發言，在我提供了這個展示之後。
And after you.
Yeah.
And owner's rep, is there anybody else from owner's rep? Just to keep.
工作室的代表就是这两位。
We'll take appearances at the beginning of each presentation. Okay. Just state
State your name for the record.
My name is good afternoon, Chair and member of the board. Thank you for giving our presentation today. My name is Xiaoping Yi. I'm the appearance of the GSA calendar number 2025.
Do you need the interpreter?
No.
No.
If I need, I am.
Okay, fine, good, thank you.
And also 2026 -098. Dr. Harry Zhu will hear as me as community representative. So the first thing is like we try to talk about we originally asked the court to revoke the partial demolition permit for 2114 and also the new building permit for 2140 Coyle Street because DOB approved them. When the
Excuse me for a
requirement.
moment, sorry, Mr. Tianyi,
Yeah.
am I pronouncing your name properly?
Yeah.
Okay. First case that we are going to hear is 2025-54A. So you need to give this presentation just for the record. I understand that there are similarities, but
okay,
for
so-
the record, you only can speak at this point with regards to 2025-54A.
Okay, so I will start presenting.
Yeah,
Okay.
thank you.
So first, the 2114 partial demolition was not a separate project. The subdivision, the RCO, the partial demolition, the BPPP, and the new building was all part of one larger common plan on the tax lot 10 and 11, about total 36 square feet. DOB argued they say the application was reviewed separately, but we found the same DOB examiner, RC Mosley, approved the subdivision on January 9, 2024, the new building application on April 2nd, 2024, and the relay of CO on August 6, 2024. This shows these are relay filling were reviewed as one connected development project. I want to bring up the question of the commissioner and also the chair member, saying the DOB is the DOB's own guideline, and we don't have the right to do anything about that. And I want to bring up these three important AC sections. So the first one is the section 28-104, point 11.2. So this AC says the applicant must determine and disclose where the project is a tower development project. If the applicant does not disclose it, this is a code violation. So this answers Chairman Shita's question. The incomplete 9M section is something the applicant should be disclosed. If he don't disclose, this is his code violation based on this AC. Secondly, the section 28-104.11.3 says the requirement DEP stormwater construction permit and also the SWPPP, which stands for Stormwater Pollution Preventing Plan, must include with the application. That means this stormwater pollution plan and also the DEP stormwater construction permit should be included with the partial demolition application, and also, I'm not gonna go to the another case. And the third, the section 28-104.11.4 says the DOB must revoke the approval, and relay permit when the required disclosure was not met. So I think this AC is pretty clear. One is like the applicant must disclose where the project is a tower development project. And second, the DEP stormwater construction permit and the SWPPP must be included with the application. The applicant failed to disclose and provide the required document, make the application legally defense.
Do I need to be sworn in?
No. Just state your name for the record.
Henry Zhu. There are several additional defects concerning 2114 Coyle Street. First, under OPPN number 30/92, the improved property subdivision required coordinated related filings and certificate of occupancy records. The related old CO for 2134 Coyle Street was withdrawn and never replaced. Second, under local law 160, the property ownership certification dated February 13th of 2024 identified Coyle Street Owner LLC as the owner, even though the company did not acquire the title until May 23rd, 2024. Third, 2114 Coyle Street is in a mandatory inclusionary housing area, but the record does not identify the required HPD permit notice, approved waiver, or outside the MIH area proof before the alt CO permit was issued.
Mr. I'm sorry to bother you. I know both of you have taken a lot of effort in putting your presentation, and as you have gathered from all the statements that you've heard from the commissioner, we have read through everything that has been provided. However, because what you're presenting to us, what you initially presented to us, are the cases that are exact statements that we stated at the beginning. Your discussion has to be only relevant to that. And marriage is not a fact. You cannot bring that up here. That is not before the board because that was not an initial case. You cannot bring up the ownership for the case number 52 because that was not brought up before the meeting. Okay? So please
Thank you.
keep your scope only to the stormwater thing for case number 1.
Thank you.
One more thing I want to bring up about the stormwater. So this is the water, the letter from the DEP that sent to the board and July 15th. So it says, given the provision of the administrative code and the application DOB received, DEP believes DOB review was appropriate. DEP does not expect DOB to treat partial demolition as covered development plan in the absence of the information. Because the information is absent, that's the DEP cannot determine anything. It's not because it's not a covered common path. It's not because it don't need to be disclosed. It's just because the application is not complete. So DEP cannot make any judgment on that. That's the letter actually is saying. It's not saying that DEP consider this is not a larger common path. I'm done with the first case. Can we go to the second case?
No, we cannot.
Okay.
Separated.
Separate.
We will go one.
The procedure is that we'll now ask DOB to respond.
Yeah.
Then the property owner can respond.
Yeah.
Then we'll ask the members of the public to speak. Then we'll go to the next case.
Okay.
And this is just because of the record, and we need to keep the record of these two. Because they were filed separately, we need to keep the record separate.
Okay.
Thank you. I'm just gonna stop the screen share and we'll invite DOB.
DOB?
Ms. Brandon?
Good afternoon, Chair and members of the board. My name is Megan Bragdon, and I'm Assistant General Counsel at the Department of Buildings. Apologies, are we doing translation?
This English translation.
Do you need DOB's?
Do you need DOB's translation?
No.
No. The appellant is saying no. Okay.
We'll let you know. We'll let you know if there's a pause needed.
Thank you. I make this statement on behalf of the department with respect to the submissions made by the challenger prior to DOB's written submission made on July 28, 2026, and in support of the department's written submission. The challenger asserts that the department's approval and issuance of permits for the partial demolition and new building applications in connection with construction at the premises were improper and must be revoked. A DEP stormwater construction permit was properly submitted to DOB before DOB issued a construction permit for the new building. The DEP permit was not required to be submitted in connection with the alt CO application for partial demolition. This application specifically indicated the work was not part of a larger common plan of development. DEP agrees that in such a case, DOB is not expected to treat the work as such. The DEP permit was properly submitted to DOB prior to the commencement of development activity, which was triggered by the issuance of the new build permit. Because the applicant already submitted to DOB the DEP permit, there was no relief to be granted with respect to this claim. Accordingly, the department respectfully requests that the board deny this appeal.
Any questions or comments?
Is there someone representing the property owner in this matter? Okay.
Now we will open it up to, do you need to?
No, he's for the other one.
now we're going to open it up to public. First, we're going to take statement from the elected officials.
The case that we're discussing is 2025-54A to 2114 Coyle Street, Brooklyn. Should you wish to comment on this application, dial 669-254-5252. At the prompt, you'll enter the webinar ID number 161864-4118, press pound. At the next prompt, you will press the pound sign only. Once you're permitted in, you'll press star 9 to raise your hand, star 6 to unmute as you're calling in on the phone. And if you're in the Zoom room already, please raise your Zoom hand, which is the little hand at the bottom of your computer screen. Thank you. That's but once you are heard, you'll have 3 minutes, with the exception of the elected officials who have more time. That's the council meeting.
Yeah.
Merci.
So we will start with State Senator.
Yes. Good afternoon, everyone. I'm Senator Steve Chan, representing the District of Senate District 17 in Southern Brooklyn. I come here in support of our neighbors in the Sheepshead Bay area. At the time that this job site started working, they actually didn't have a state senator. So I kind of got involved because they were reaching out to me for help. And I'm very, very happy to represent our community over there as I consider myself to be a people's senator. And today I heard everything from examples of how something is routinely done. People routinely ride their bicycles on the sidewalks of New York City. People routinely make U-turns in New York City on our road. That doesn't make it proper, and it doesn't make it legal. I feel that this board was somewhat biased from the get-go from what I've been hearing as an observer. And I feel that the evidence presented both in the PowerPoint and in the letters from the challenges to the BSA was legitimate and with merit and very compelling. So I ask, I've also seen in another case where a developer was scrutinized or you guys nitpick on his application, on his, so with that said, I asked the board, consider what our neighbors presented to you, and I find a lot of these evidence to be actually legitimate. I can't help but feel that the Department of Buildings has skirted their own bylaws and administrative codes, as well as the Board of Standards and Appeals have done that. So I hope that for future reference, that the board is truly committed to remaining unbiased towards my constituents as well as the neighbors of New York City, between them and developers. Thank you very much.
I have. First of all, we're not biased. Three. Second, you're indicating that like too many evidence that was submitted to us are compelling and we support the request from the tenant to revoke the permit. Based on what? Okay, tell me why you single evidence that was submitted and it is in support of that permit.
Commissioner Shetland, I think State Senator and the public person is entitled to their opinion in their statement.
I wasn't aware that this was a debate, I'm sorry.
No, I'm totally agreeing with that. But if you know one single evidence, please let us know.
Well, you just heard from,
So
you guys, for instance, right?
You can't, so we choose the mic, because it,
For instance, right, let's talk about supportive housing. The original application for this development was for supportive housing. And with that said, right, and affordable housing is great, we absolutely need it in the neighborhood. But this was a classic case of bait and switch. The application submitted was for supportive housing, not for a homeless shelter. That was switched along the way. The stormwater, to me, the DEP, the Department of Buildings clearly violated their own bylaws and administrative codes. They did require, the DEP permit was not submitted.
Thank you, Commissioner.
I'd just like to make clear,
For this item number 6, we are discussing the relevance of the DEP stormwater permit and whether this is a covered development project.
And the AC's code is crystal clear on that, and it doesn't prohibit issuing a permit
Commissioner Shedder.
without the stormwater.
Commissioner Shedder,
Thank you.
and all other commissioners, I think the board on record has made it very clear as to where we stand on this. We do not need to repeat it. We have a lot of speakers who are going to testify. Please give them the opportunity to speak.
And I really appreciate your results.
Thank you very much.
Thank you, sir.
I appreciate you too. Thank you.
Councilmember Narcisse, I hope I pronounced it correctly. Juicy? Okay. You want to mute yourself, Anna?
Good afternoon. By now, we're starting in the morning. Thank you to everyone. Thank you. Good afternoon, Chairperson and members of the board. I am Councilmember Mercedes Narcisse, representing the 46th District. I see that it's a hard work. You spent all morning going through everything, but I want to be clear about why I'm here. This community was met with a bait and switch, and instead of walking away, they went to work. They pulled the data, they've been showing it back and forth in my office, they cross-checked them by hand to find out the gaps that the city agency was supposed to catch from the beginning. I am here because they deserve to have that work taken seriously. They worked very hard. And I understand that you work very hard too. Here's what I meant by bait and switch. This community supported the zoning and development process under understanding that this site would be affordable housing. That's why they were presented here today. They're fighting because that's not what they voted for. Somewhere along the way, without the community being told, the plan changed. The application filed with DOB still described this building as a DHS sponsored supportive housing. But the document actually recorded against this property describes something different, a homeless shelter for a term of 40 years. Nobody came back to this community and said the deal has changed. They found out by digging through the filing themselves. It is a fact. My constituent found that the person who signed the ownership certification for this project swore to DOB in January 2024 that this company owned this property. City records show that the company did not actually acquire the title until May of that year. He certified ownership 4 months before he had it. And that this community of my office still doesn't have a straight answer about whether the required notice to HPD, one that's supposed to happen before any permit get issued on a site like this, was ever filed. They were probably never filed it at all. My office raised this question directly to DOB and HPD. We have not received a single straight answer. I want to be direct to this board. Every one of these issues traces back to DOB not following its own rules, not my rules, not this community's rules. DOB's own procedures, its own service bulletins, its own administrative code. The disclosure requirement, the ownership certification standard, the MIH notice requirement, all of it already exists on the books. Nobody is asking DOB to do anything new. We are asking DOB to do what is already required of every other applicant in the city. And I'll say plenty. My office has had a hard time getting DOB to engage with us at all of this issue. For all the sites, especially since March when a gas line was struck during unpermitted work here. This is a community that was told it was getting one kind of a building and maybe getting another on a site where the ownership documents don't add up. The required notices can be produced, and the agency responsibility for enforcing its own rules has gone quiet. I am asking this board to take my constituent research seriously, to require DOB and HPD to produce what the laws require, and to use its authority to get the answers this community has been asking for and never received. If the applicant cannot produce what is required, and I know the board will do the right thing.
So
Yeah,
I think.
yeah.
Just, if you want to clap, just go this, that's way everybody can hear what council member anybody's saying, okay? If you support, go this. All right, good, thank you. Thank you, council member.
Thank you. I'm stressed.
Thank you. Any other elected official that's in the room?
And I would also, if both council member and State Senator Chen, if you want to submit your statement, what you have stated, email it to us, we put it in our record also. I just want to say for the record, what is before us is not the bait and switch. If it's a permitted use, it's a permitted use. That is not the action that is before us. And what is before us are these issuance of these permits. And from everything that I am hearing so far, the issuance of the permits are related to DOB's internal rules and policies and not related to the admin code. The rules and policies, when they were promulgated, that was the time when the community or the public should have opposed. Since it has gone unchallenged at this point, what is before us is how the rules is applying and its consistency with the administrative code and the charter. I just want to make that very clear. Now we will open it up. Any other elected official in the room
Or on Zoom, please raise your hand.
Any other elected official?
Okay.
We'll start with the list we passed around. Elliot Myers, would you like to speak?
2026-09A.
Okay.
Oh, okay, so this.
Okay,
They did not ask that. That's what it is for.
Okay, the next person is Benjamin Louis. You'll have 3 minutes. Do you need an interpreter?
Good morning. Can you hear me?
What's your name for the record?
Benjamin Louis? Yeah. So my name is Benjamin Louis, and I support calendar number 2025-54-8. DOB's property profile identifies 2114 Coyle Street as an MIH area property. Before DOB issued or renewed the related ALCO permit, the applicant was required to provide an HPD permit notice, an approved waiver, and a ZOA proof showing that the property was outside the MIH area. The record identifies none of those documents. DOB nonetheless issued the ALCO permit on September 24th, 2024, and renewed it on September 26th, 2025. These are prior to permit requirements. They are intended to make sure that the mandatory inclusionary housing applications are reviewed before work is authorized. The absence of the required documents cannot be treated as harmless simply because DOB issued and renewed the permit. The board should require DOB to follow the same MIH procedures for this property that it publishes for every other project. Because the permit was issued without the required documentation, the board should revoke the challenge permit and related improper approvals. And I'm done.
Thank you. Again, this particular case was regarding stormwater and not MIH. Next speaker?
Next speaker, Chris, pardon my pronunciation. Chris Chiarotano? Chris Chiarotano?
For next case.
Oh, for the next case? Okay. Okay, Kelvin Ho? Yes.
Do you need an
My name is Kelvin Ho.
You need interpreter?
No.
Okay.
Good afternoon, BSA chairperson, BSA members, and everyone. My name is Kelvin Ho, and I'm here today in support of calendar number 2026-09-8.
Oh, wait, that's the next case.
Next case, it's the next case.
Sorry, okay. Okay, Wyvin Hyang? Next case, okay, no, CJ, but Jianhua Chen? Jianhua Chen? Same case? but only for 2025 54A, not for 2026 09A. Okay, do you want to?
Yeah.哦，你需要翻译吗
No.
？OK。
Oh, so it's not for that? Okay, so you're here for 2024 54A?
你是为了2025-24吗
Yeah, next.
Okay,
Mr.
okay.
Clark, if you would just interpret, if there are any members of the public who would like to speak on this case.
Yeah， 所以现在就是有没有公众因为2025-54A 的这个 case 要发言有吗？
You want to raise your hand? Like,
啊？轮到你。OK, should be on next.
Okay.
OK, 好。
for this case?
是的，2025-54A 对吧？
Hi, good afternoon, everyone. My name is Andy Wong.
Oh, yeah, I have.
Normally, when we apply the application, if some checkbox was empty, I will get rejected because the application is not completed. Okay? But this gentleman just told me they don't need it. I'm surprised. Can you explain for me? Why you don't need to, empty the checkbox?
I didn't say that.
You did say it.
I said it's irrelevant.
Oh, okay, so why you need to complete the application? There's no need to, right? So if you can do it, everybody can do it.
Okay.
All right, so second, the DOB requests only the owner can fill up and submit the application. But the application, but the applicant was not the owner yet. He become the owner after 4 months later. DOB still can accept it. So that is a question, In here, everything is wrong. Thank you.
Thank you. Next speaker, could you announce again, because there's a lot of people in the Zoom room, if they can raise their hands.
Anybody who is in the Zoom room, ask them to raise their hand if they want to speak specific to case number
54A.
54A.
OK，如果有大众在 Zoom 那边等待，你要因为2025-54A 这个 case 要发言的话，请你举手，也在那个 Zoom 里面举手。还有吗？因为有很多人在等待，在Zoom 上面有 Zoom 的等待的大众。因为2025-54A 要发言吗？请举手。
I don't see anybody's hand. I'm just going to give one more minute, just it takes time for somebody to.
The case we are currently discussing is item number 6, 2025-54A, 2114 Coyle Street, Brooklyn.
那现在我们正在讨论的是2025-54A 这个 case，2114 Coyle 街 Brooklyn 这个地址。
I do not see anybody's hand being raised to speak on this particular subject matter. Commissioners, do you have any other statement or anything to make? I think based on everything that I have heard so far, there is a unanimous position.
We have one member from the public in the waiting room, Bert Fajardo. I will promote to panelist. Or allow him to speak.
Hello, everyone. Thank you for the opportunity to speak. Are we still on are we on the second case now? Or
No, we're on the first case too.
Oh, my apologies. I'll speak on the second.
Okay. Good. idea fill-in, and in expressing the concerns, I am not convinced that the issues raised rises to a need for a revocation. And as stated earlier, the board is an independent board. Each of our board members, we review independently, and we review each and every document that is submitted, and we deliberate on it independently. And independently, all 5 of us have come to the same conclusion, and that is, does it comply with the statutory laws and the common law practices based on what is practiced as part of the common law, which are legal guidelines and principles the board follows, and based on the legal guidelines that is given, that we have to abide by statutory laws, that is in the administrative code. I feel the board sees that there is no ground for revocation. So I'm not going to belabor this part of this hearing anymore, and I'm going to make a recommendation that we close this hearing and the record is closed, because we have we have a lot of information, more information, and I don't think any additional information is going to change the opinion of this board. So I'm going to recommend that we close and the record is closed. So,
Motion to close, Chair Shanda.
aye.
Vice Chair Shabeta. Commissioner Otley Brown.
Aye.
Commissioner Shetta.
Aye.
Commissioner Yu.
Aye.
Okay.
Next case, please.
Now we proceed with item number 7, 2026-09A, 2140 Coyle Street, Brooklyn. Want to do that?
下一个要作证的是2026-9A 的这个case。
Okay, Mr. Please state your name for the record again.
Shao Feng.
I'm again going to remind everybody that please keep your comments relevant to the core issues that were raised in this particular case, and not any other subject matter that is not relevant to this is not going to be considered by the board. I'm going to ask the speaker to not discuss it.
The new building case. So I can to bring back to this same three stormwater administrative code that apply here on the new building permit case. So let me repeat. The AC section 28-104.11.2 require the applicant to determine and disclose the stormwater condition. But on the original PTP-PW1, it had the application with this 9M session rank. And later, the amendment PW1, which on the exhibit DOPA2, they put the no on the 9M. So for me, it's a clear validation of this AC code, section 28-104.11.2, because the applicant failed to disclose the information on the beginning. And the new building permit has been approved without the required stormwater permit. So the AC code section 28-104, 21.3 require the DEP stormwater construction permit and the SWPPP to be included with the application. So DOB approved the new application on April 2nd, 2024. DEP did not issue the stormwater construction permit until February 10, 2025, more than 10 months later. So this is, for me, is the clear violation of the AC code 28-104, 11.3, because it says stormwater permit as the SWPP are required document before approval. And then the section 28-104, 11.4 will allow the relocation when the requirement disclosure was missing or is not come with the required document is not come on with the application. So the rule is very simple. Disclose it first and submit the required document before approval. That did not happen here. For this reason, the late DEP permit did not cure the problem that already exists on the DOB approved new building application.
Henry Zhu. The improved property subdivision affected 3 existing buildings, 2114, 2134, and 2150 Coyle Street. DOB's subdivision code notes required a related alteration filing for each affected building and tax lot. 2114 had a related filing. The 2134 filing was withdrawn on October 8th, 2024. No replacement was identified. For 2150, no related Alt 1 or Alt 2 filing was identified. So the subdivision, related filings, and certificate of occupancy process were not fully coordinated. And I asked a very simple question, which is, how do you know when something's wrong? How do you know when something's not being followed?
So let's go back to the subdivision problem. So I want to bring up this administrative code 28-1.4-7.18. It says the applicant must identify whether the zoning lot has one tax lot or multiple tax lot. If it has multiple tax lot, the applicant must provide the required CO, the certificate of occupancy information for each lot, which lot 10 and lot 11. The section, the administrative code section 28-1.4-7.18.1 and also section 28-11A.2.3.1 then require the effect owner to obey any required or new amend certificate of occupancy within the capable 1-year period when the address, plot, lot, or zoning lot information has changed. The new building zoning lot have tax lot 10 and tax lot 11. which on our reply exhibit to DOB C1. This is a new building CD1 file. It indicates we have test log and test 11. But on the new building PW1, it only disclosed the log 11, which is the validation of this administrative code 28-1.4.7.18, and also the AC code 28-1.4.7.18.1. Because these two AC code require the applicant to define the zoning law, this test law, and relate CO information. And the DOB approves the new building application. Displaying the incomplete zoning law and test law disclosure. So that's the another slide that repeating that I mentioned before. This is another requirement for the effect test law owner to obey any required new or amendment certificate of occupancy within a capable 1 year period. So you can see the new building approval is happened on April 2nd, 2024. And 1 year compliance period expired April 2nd, 2025. But the CO is on the DOB exhibit C2 on our reply submission. This is the current CO of the lot 11. It still shows our address, which is 2140. Continue on the subdivision. Because there are no CO for this building, and I just want to bring up this house number approval requirement. The RCNY Title 14, Chapter 1, Section 1.01, procedure for issue of house number. So basically it's saying, for the address, new house number approval, it will be required the applicant to obey house number verification stamp on the back of the PW Fund 4, tax bracket unit of the Borough Passenger Office. 2140 is not a valid house number even. So let's look at the exhibit on our reply to the DOB exhibit D2. The official record from the Borough Passenger Office shows the house number 2130, 2134, and 2150, 2154, 2154, but no 2140. So the new building permit actually using a non-existent house number. So I don't know how can they do that. I mean, for me, it's basically it's a total violation of this law. And I want to.
I hate to keep breaking into your presentation, but this factor is not in your initial content.
Yeah, it's related to the subject.
It is not related. It is not related. And the housing number and all of that, I can't even begin to talk about it. I don't even think it's in DOB's jurisdiction. It's a number that is provided by Department of Finance, and DOB just accepts whatever is provided.
Okay.
So, and it's not before us, and I do not want to have any discussion on that.
Okay. So can I talk about it now?
I'd like to just state for the record that Coyle Street 2130 is a range address from 2130 Coyle Street to 2140 Coyle Street.
2130 to?
2130 to 2140, inclusive.
So let's continue on the subdivision. So the DOB memo dated May 18, 1978 is commonly called the 1917 Mickey memo. It says one zoning lot has more than one owner. So that's the case here. So when the new building permit, they have multi-tax lot and multi-owner.
Was that in your initial statement?
Yeah, it's the subdivision related, it's because we have our original submission, and then DOB reply us, and then we reply on the same.
I understand the process.
Yeah.
However, when you are responding to DOB's comments, you cannot add new elements.
Yeah,
You
that's
have to stick to the elements that were presented before or respond to DOB's questions, but not adding. And I think from what I read from the submissions made, there were elements that were added that were not in the scope of the initial review or in DOB statements.
But how can we, reply, use more
The
evidence?
reply is whether it's correct or not, or whether the same regulations have been applied judiciously, legally, case laws, or other things based on which you can.
Yeah, so that's
based on
what I-
evidence. This is not based on case laws or evidence. You're adding additional factors that are not before the board and that was not cited in the initial challenge case that was presented to, against DOB. So it would not be, in other words, you're adding new challenges which DOB or the property owner was not privy to initially. And you're asking them to respond to new items to be challenged to, which were not originally there. We are only sticking to what was originally there. And
So if we want to bring up this question, we have to
only based on
fulfill the
those
new
four-
PSA
only-
case?
I'm not saying anything, but I would warn you from everything that we have heard here, the ground is not there.
Okay.
But if you want to present the case, stick to the case that you have initially found. Those 4 items that I mentioned at the beginning, that is in your initial letter, are the 4 points on which you have to make your statements.
Chairman, I think it's related because the DOB respond to us because the zoning law is not changed. So that's why the new building permit don't need the subdivision to be finished. So that's why this evidence is zoning, even though the zoning law is not changed.
Zoning law, and I would state this board is very well versed with zoning law. We have dealt with many of these cases related to zoning law.
Okay,
And
so,
I will tell you that zoning law can have multiple owners. Zoning law can have multiple tax lots. And each tax lot can have its owner, and therefore, a zoning law can have multiple owners. So that it is not a finding at all that is raising any issues with this board.
Oh, okay, but, yeah. I
There are
understand.
there are case laws very clearly outlined, and this board has deliberated on many such case laws.
Okay.
Thank you.
Okay. The point is like, it's not a zoning law with multiple owners. But what I try to bring up is the multi-tax law with multiple owner need to follow the instruction of the 1917 Mickey memo. Is that something we
And
can talk about?
and we do follow a Minkin memo, and the Minkin memo does allow multiple.
Oh, yeah, but this is not the point I'm trying to say here. I want to say something else. But relate. Sorry,
Go ahead.
So the Mickey memo says when one zoning law has more than one owner, the zoning exhibit 2 is required before the building permit is issued. The record document under the CRFN 2023-00032 A9A5. This document is actually a zoning exhibit 3 document. On the subdivision, the LCO filing, it put it on the exhibit 3 position. But on the new building filing permit, it put the same document as the exhibit 2. So the new building filing using the exhibit 3 document on the exhibit 2 field. Neither DOB or owner on their, has identified separate recorded zoning document exhibit 2. So the required exhibit 2 is missing from the record when the building get, new building permit get approved. The new building permit get issued.
I'm trying to understand. I'm not sure what is the connection, what is the next between that and the need for a revocation?
Basically, it's saying it validate it use in the false document and it missing the zoning document exhibit 2 on the new building application. Because
Is it a false document?
Because that document is exhibit 3. They use the same document, just put it on the exhibit 2 field, the entry, but that's not the exhibit 2.
So do you think that let's say this ministerial error was corrected?
Exactly, yeah, so they use the wrong document to fill on the field. They're supposed to have the exhibit 2.
And
but don't have the exhibit 2.
But if it has been corrected,
Do you think?
what is the issue that would prevent the permit being invalid?
If they can show us the real exhibit 2 document. But right now, we don't have the zoning exhibit 2.
And they filed a 3 instead.
Yeah,
But then refiled exhibit 3 as exhibit 2.
yeah.
Okay, so what they did was then fixed.
Yeah.
No, they didn't fix it.
No, he's saying
It's
it's
still,
still.
that's why we bring it to the board right
I think
now.
that needs to be clarified, because if you can, if DOB has the authority to accept an exhibit 3, which is an owner's statement of the zoning lot that's recorded against the property, and they're allowed to accept that as an exhibit 2 for the sake of meeting these needs, then that is, it's either an error or it's either been accepted by DOB as serving as the function of an exhibit 2.
There needs to be
It's more
some.
than its title.
There needs to be
Document-
support for your statement that exhibit 3 cannot simply be relabeled to satisfy the exhibit 2 requirement.
Yeah, because on the meeting memo, the subdivision C says if the tax lot have only single one owner, you submit the exhibit 3. And if the tax lot have multiple owner, you have to submit the exhibit 2 along with the exhibit 4 and 5, 4 or 5, in order to satisfy this requirement. So that is not happening here. So we don't have the exhibit 2 on the new building file. It's not listed. That's why I'm saying exhibit 3 cannot simply be reliable to satisfy the description exhibit 2 requirement. So
Okay, so and that would be enough to revoke.
Yeah, I'm still trying to find the
Our
connection.
next is
What-
that, so sorry.
No, go ahead.
So, is that what what would end up having these permits revoked? Is that the only cure here?
Is that the only deficiency?
No, is that the only cure? The only cure is they
Is this incurable?
It is incurable.
if they can show us the real zoning exhibit 2 and file on the zoning as that have been filed, that will be good.
I think
That's not the case here.
We need, I think that maybe DOB can clarify that, but I still do not see how that is a ground for revocation of the permit. What DOB needs to ensure, the Department of Finance, also DOB in this case is relying on what the Department of Finance is providing, but what we should ensure is that all the properties in question affected by the zoning law are fully aware that there is a development happening, and all parties are aware of that, and they have signed on to an agreement. And excuse me, and based on that, I think if I were to interpret from DOB's letter, DOB has not received any issues of any, or any concerns raised by any of the property owners that are within the zoning lot or lots abutting the zoning lot. So I don't think there is any issue issue associated with it, associated with it, warranting a revocation. Be that as it may, just for the record, for the completeness of the record, if an exhibit 2 is required, that's a different story, but that still does not lead me to believe that this board should revoke a permit because the exhibit 2 is the same as exhibit 3, or exhibit 3 was incorrectly presented as exhibit 2, or vice versa. DOB has to determine that the zoning law together was legally all correct, and DOB can respond to that. Okay?
Yeah, I agree with that assessment, and the point is more that we're building the case that there are multiple things going on here that are not being followed, and I agree that it's just not this, that we want revocation simply because of the things that we're exhibiting. It's for you guys to see that maybe there's something being missed. Maybe there are improper things that are going on. Maybe if they ostensibly are very competent, developers that they would follow letter of the law. They have very competent people, right?
Mr. Su, all I would say, you're absolutely, I think you've done an excellent job of looking through every code that would be applicable. And we have looked through those documents that you have provided and your team member. All I would say is that so far, based on everything that we have reviewed, what DOB states as part of its checklists and rules are not the, as we call the statute. What is the statute? The statutes are what's in the administrative code, what's in the charter, what's in the building code, what's in the zoning code, what's in the case laws. And so far, none of those evidence that you have provided convinces us to believe that these changes of a wrong home address or the MIH or the subdivision or the property ownership, and property ownership actually they're totally consistent in the administrative code. You may not like the way it is practiced, but that is the standard practice. It is the practice that has been approved by the case laws, by the court. Court sees us that way. We follow the same principles that court guides us with, and that's the common law. That's what we call common law. So court guides us, we follow that law. Our board follows it, DOB follows it, all other practicing agencies or any practicing lawyer dealing with land use laws or property laws deals with that. So it's nothing inconsistent. So you may dispute the common law. You should take that to the court and question the common law and why it is being practiced. We are not that. I'll make that, because that statement was made earlier during the public testimony. I just want to make it clear. Our hand is very much tied, and it's very much limited to those factors. We cannot write the law. You want to change the law and you want to bring it to us, that's a different story. We cannot change the law. We're just interpreting the law that has been presented before us. So based on that, the ownership factor is not at all a factor, because it is a common law which states that you have the right to, if you have the proper equitable interest, thank you, then you are entitled to file the application, which has been done appropriately. So let's put that aside. You really cannot bring that up because we have case laws that support that evidence, okay? Now,
It's beyond case law. It's defined in 28-101.5 of the admin code. Owner is defined as any person, agent, firm, partnership, corporation, or other legal entity having a legal or equitable interest in or control of the premises.
and the equitable interest is what this particular owner has, and therefore it is absolutely permitted. So that is one part. With regards to, again, zoning law, you can have multiple owners. It's for the clarity of DOB to ensure that every property owner on that zoning lot is aware of it and has been. But that itself, that itself is not a reason for any board to have to revoke the application. Because yes, it's a document that needs to be signed and that has to be submitted, and it may have been, as your study have shown, there are just so many pieces of this puzzle. Every piece has to be done. and there will be inaccuracies. But the question is, how inaccurate are they that prevents this building permit being revoked? This has to be egregious enough where it's causing safety and security and harm to the immediate neighbor. It is being structurally being instabilized. It is causing unusual environmental damage. None of those are the situations in this case. What is concerning you, I'm gathering from the discussion, is the fact that somebody had suggested a supportive housing, but instead has made it into a homeless shelter. But that is not before us. That is not at all before us. What is before us is this permit valid, regardless of whether it is for a supportive housing, regardless of whether it is for a luxury housing or for a homeless shelter. Is the permit valid? In this case, regardless of what's housing typology or building typology, is the permit valid? And so far, every evidence that's been provided here does not speak in the way you have outlined. I'm just making it
No,
clear.
I understand, and thank you for bringing it up, because it answers the question that I would have posed to the board, which is, how would you know that something is, again, going wrong? So, there's two things I want to bring to your attention. One is in the NYC, again, DOB building notice, service notice in 2021 that clearly states and what the property owners are to be listed on a property certification form. And then you mentioned community safety. So do you guys know what happened in March for this building, for this property?
Is it there on your challenge?
Is this relevant to the DOB's approval of this construction document that's being challenged?
Because they approve of the new building permit, despite there being local law 160, if there are more than $25,000 in arrears, if there are violations that add up to more than $20,000.
I'm so sorry, local law 160 is not, your appeal has not been predicated upon compliance with this local law.
Yeah.
This is outside the scope of
It
this
is
case.
outside the scope of this case. You have to keep it within the scope of this case.
I mean, this is part of the original appeal.
No, it's not
No, it is not part of the original.
No,
This specific document is part of it's the second, it's number 2.
Yes, it's literally.
It's argument number 2.
It is.
It's literally in the exhibits.
Yeah.
But he's citing the service notice as law.
No, the service notice, yes, but not the local,
This certification
The property owner
exists
certification.
to say, I
Yes.
do or do not owe the city more than $25,000. And they're in this service notice describing what you need to do. It says that you should be the owner as defined by Department of Finance, or established by Department of Finance.
but that's that.
This is the service notice, which we've established that the notices that are
Thank you.
issued
Yes, thank
by
you.
DOB for the courtesy of the public as guidelines are not law.
Sure.
No, but the local law is
To your point is that it would be very easy for us to find out if the DOB followed and looked on DOF. And we have FOIA requests, and they did not look. They didn't look at who the owner was.
How would you know that they didn't look at?
Because we asked specifically for their searching of the files, and we have all the FOIA requests, we have all the correspondences with DOB. CM Mercedes Narcisse will attest that we asked specifically for these documents. They have to file that they looked through the DOF records, they did not. But that's where I leave it to you guys to see if there's something wrong here for this specific development.
Where in the service notice does it say DOB has to conduct their independent investigation into the filing?
Yeah.
Okay, so one thing here, I want to specify, the owner on the AC, the definition on the AC code that they'll be bring is different to the owner that we present to the board on original, okay, original. We're talking about the local law of 116 of 2017.
Recording stop. Recording in progress.
Hold on.
Okay, we're talking about the
Hold
local.
on, the recording.
Oh,
Say a word, not a
Don't
word.
say anything.
It started again, but we should.
Carlo, are we good?
Yeah, it's showing it's recording on this end.
Okay, please go ahead.
I can continue to-
Yes.
Okay. So the purpose of the owner that you mentioned is on the general owner, on the AC, on the AC. But this ownership certification, the purpose of this certification is seeing the DOF owner, how many fine or another tower arrest has been owned. When the permit is issued or application is applied. So it's very clearly saying for the purpose of property ownership, the certification form, that's the form that they use the soon-to-be owner side. This owner that defined on the local law 160 is the property owner reflect on the NYC Department of Finance, DOF record. David, the guy who signed, is not the owner that on the MOF record. If the owner is, unless David is also one of the owner that has been listed on the DOF record, then he can sign.
Can I say something? If you are contesting that the person who signed here lied and there were arrears, or if you are saying the zoning exhibit 2 was not presented because there are questions with the zoning lot boundaries, or it's something material, something that actually impacts the approval and the permit, we would have something to go on. But we're talking about stuff that has no actual impact on the proposal and the permit. You're not contesting that there are arrears or that this property has done something actually wrong. You're saying that there's an administrative or clerical disconnect, and that's why it doesn't compel me. Does that make sense?
Let me reply, Commissioner Young. So what we're talking about is not only document error, we're talking about this procedure error is violating either the AC code or the local law.
Okay, so is there anything, just what my question is there anything that you were talking about that that the only cure would be revoking this permit? And if you have, and I would actually take that question and I would go back and when our next hearing date, write out what or a next date, or before you put it in writing, that there is something that happened here that requires and have show precedent and case law that something that happened here requires a revoking of the permit. Put it in writing, don't make it very verbose.
No, I think before we get there, what we are all struggling to understand, what is the nexus between the fact that you're raising that has not been provided to that issuance of the permit? Where is the disconnect? What, by not providing that information, how is it harming the construction? How is that harming the development? How is that harming the neighbor? How is that causing undue harm to the neighbor property owners? I don't see the connection. I don't see the connection. So those are not grounds. There could application forms, there could be mistakes here and there. But are those mistakes? I'm not saying that every application form is perfect. And I do not know and I do not need to know. But the fact of the matter is, how egregious is that information that would, as Abhishek Shibera said, that says based on laws that's been promulgated in various courts, that states therefore we should revoke this permit. You have to be able to give us that case law. We have not so far found any case laws that support that.
The commissioners are suggesting, if they agree with your argument, what is stopping the commissioners from requiring compliance with these provisions and then nevertheless having the permits continue?
Because based on what we are reading, we are failing to see where they are in violation of the administrative code.
And I would say what's at stake on the other side of the scale is a multi-year, hundreds of people effort, including city agencies, taxpayer dollars, to put this process and to get this approval and permit. I know that there's a bait split that is part of this larger community concern, but that is not before us. We're saying these administrative or clerical discussions stand against this huge effort that has been made to make this project happen. So it's not, we're not finding the equal balance here between what you're proposing and the revocation.
Yeah, so that's what we point out, this administrative code 28-1.4 and 11.4, revocation of approval of construction document.
If we do, would you guys want evidence that there's wrongdoing? As in, literally on the project, would that be?
That's not what.
That is not what is before us.
Then why should you talk about it?
So.
Please still.
Let me finish. So, respond to the member. So, the first code I will say, administrative code 28-1.4, 11.4, renovation of approval and construction permit. When a department finds after approval of construction document, that has a
Construction
compelled.
document approved prior to this?
I don't want to interrupt. 28-104-11-4 states that the department has the power and the authority and the right to seek the revocation of such documents. But this section 28-104-11-4 does not create a private remedy for a member of the public to seek a revocation.
I think you're fascinated. Charles, for 15 years, good question. I think get us something, if there is anything, that shows that this permit should be revoked and case law that supports it. And as Commissioner Yu mentioned, we also consider the balance of the equities. So I understand the community's concern.
I absolutely, at this point, I think we need to go to the next, if there's any particular thing that we want to ask, please go into that, because I need to give the floor to other people.
No, so we continue with the conclusion. So for the calendar number 2024-58, we asked the board to report a termination permit for 2114 Coyle Street. For this, I'm sorry, this is the calendar number. For calendar number 2026-098, we asked the board to revoke the new building permit for 2140 Coyle Street and reverse the relay approval. This is not small clerical mistake. They involve stormwater subdivision and certificate of occupancy record, zoning law information, ownership certification, and violation of the zoning resolution for supported housing. I am not allowed to talk about that here. We only ask the DOB to follow the law and apply the same rule fairly to everyone. We are asking DOB to follow the law and apply the same rule to this project. Thank you.
First it will be DOB, then it will be owner's rep.
Good afternoon, Chair and members of the board. My name is Megan Brandon, and I'm Assistant General Counsel for the Department of Buildings. I make this statement on behalf of the department with respect to the submissions made by the challenger prior to DOB's written submission made on July 28, 2026, and in support of the department's written submission. The challenger asserts that the department's approval and issuance of permits for the new building application in connection with construction at the premises was improper and must be revoked. However, the department's approvals and permits for the subdivision, alt-CO, and new build applications were proper, and the order of such approvals were proper. Additionally, the claim with respect to owner authorization is without merit, and the challenger lacks the authority per the department's code to make such a claim. First, the challenger incorrectly asserts that the subdivision of improved property, the SI application, should have been signed off before the new build application is approved. The challenger points to the DOB Now Required Items Reference Guide and indicates that it establishes a mandatory sequencing requirement. However, this guide is not a binding authority. The challenger is mistaken that the SI application must be approved prior to new build approval. A new build application approval is based on the meets and bounds of a zoning lot and not a tax lot. As long as the zoning lot's meets and bounds remain the same, there is no requirement for an SI application to be signed off prior to new build approval. Nonetheless, the SI was completed in January 2024 prior to the new build application approval, which occurred in April of 2024, according to Biz and DOB Now records. Additionally, in connection with the new build application, DOB allowed a deferral of the submission of the DEP stormwater construction permit from before the new build construction document approval to before the issuance of the new build construction permit. The challenger points to a reference guide, the DOB Now waiver and deferral document request list. Although this guide does not list the DEP permit as being eligible for a waiver or deferral, this list is not binding authority. DOB's allowance of this deferral is supported by Admin Code Section 28-105.1.2, which states that it is a violation of the code to engage in the relevant development activity without a DEP permit. However, here, a DOP permit was submitted prior to DOB issuing the new build construction permit, and no development activity could have occurred without the new build construction permit. Therefore, there was no relief to be granted because the DEP permit has already been submitted to DOB. Second, the challenger incorrectly claims that the documentation was not signed by the owner. The documentation submitted in connection with the new build application, specifically the property ownership statement and the street tree checklist, were in fact signed by an owner pursuant to DOB's Admin Code Section 28-101.5, which defines an owner as any person, agent, firm, partnership, corporation, or other legal entity having a legal or equitable interest in or control of the premise. David Schwartz is the signatory for Coyle Street Owner LLC on the documentation. Specifically, this entity had entered into a contract of sale as purchaser of the premise at the time. Accordingly, the entity was a contract vendee with an equitable interest in the premise at the time of signing the documentation. The department does have a copy of the contract of sale evidencing this, and will provide it to the board as part of a written submission for the record. Additionally, the challenger is not the proper entity to bring an owner authorization challenge pursuant to Admin Code Section 28-104.8.2. This section authorizes the department to revoke construction document approval if it receives a complaint from an entity with a valid property interest. Not only has the department not received any challenge to the approval of the alt-CO or new build applications from such an entity, but there is no record to demonstrate that the challenger falls within this criteria. Accordingly, this is not a proper claim for the board to consider. Therefore, the department respectfully requests that the board deny this appeal. And I'd like to add that to the extent the board wants DOB to respond to any of the additional arguments raised since the original submission, I will address it in a further written submission.
Thank you. Any questions for DOB? Is there anyone else with you?
Sure. Good afternoon, Chair, Commissioners. Richard Lovell of Sheldon Lovell PC
here with Ms. Van that's on for 2134 Coyle Housing Development Fund Corporation. Not seeking to belabor the discussions of the board. Obviously, there's been a tremendous amount submitted, so I'm going to reduce and limit my comments to several main points. The first is the statement of facts and findings of the applicant in this appeal, who basically, as was noted by the chair and the commissioners, raised 4 points. One was with regards to the sequencing of the application in terms of the new building application. The second was with regards to the property's owner certification, both in the context of the application for a new building permit as well as the street tree checklist. And then the fourth was for the deferment of the stormwater construction permit. So those are the 4 points that were raised. I understand that the applicant, pursuant to voluminous submissions, has raised numerous other points, including testimony here before the board today. I would say that that's improper. I would note that the DOB response to the applicant's submission was limited to those 4 points only. And so with regards to these other conversations, the chair is correct in stating that the applicant should limit their discussions, and to the extent that there are further questions from the board or it's required, we would reserve the right to submit on that. Having said that, I think that it's improper at this point to address these items. With regards to the substance of those comments that were made, with regards to the sequencing of the application, DOB has already answered the points that the checklists that are provided for applicants for new building applications is as a courtesy to applicants. It does not rise to the level of law. And as has been noted in the cases cited to the board, specifically Bayswater Health versus Carsey-Dunoff, a number of factors, is a quote, a number of factors give strong support to our view that failure to receive prior certification, in this case for a health-related facility, was a mere irregularity subsequently cured as to each of these permittees, which goes to the substance of this dispute, which is that to the extent that you are successfully able to submit to the satisfaction of the Department of Buildings, that should be the end of it. As it again was cited in numerous cases before the board, Department of Buildings is well able to administer its own regulations. Do any of the allegations that were made by the challenger rise to the level of an arbitrary or capricious action, something that is against the law? And they do not, as was noted by Mr. Yoon as well. So it's important to realize that both in terms of the sequencing of these applications, as well as to the allegations in terms of the owner's authorizations. I will not belabor the citations in terms of the administrative code, but also in terms of the case law. The owner as contract MD at the time of execution of these documents was well able to sign as an owner of the property under the necessary definitions. So, to summarize, again, while there has been voluminous materials submitted by the opposition, these don't go to the core question here, which is whether or not DOB adhered to its own practice and procedures and policy, which they did. And again, none of the allegations here go to a substantive issue which would demonstrate that the applicant here was doing anything illegal, was purposefully obfuscating any of the provisions that DOB has set forth. And so the application should be, and the appeal should be dismissed in its entirety. And I'm happy to answer any questions from the board.
Thank you.
Thank you, Commissioners.
Now let's open it to the public. We will start with elected and the standard statement. The statement first.
Jolly, can you share the screen? Just let me, I have to do a statement first.
Appreciate notice.
The case we're currently discussing is item number 7, 2026-09A, 2140 Coyle Street, Brooklyn. Should you wish to comment on this application, dial 669-254-5252. At the prompt, you'll enter the webinar ID number 161-864-4118 and press the pound sign. At the next prompt, you'll press the pound sign only. Once you're permitted in, you'll press *9 to raise your hand, *6 to unmute if you're calling in on the phone to be able to be heard. And if you're in the Zoom room already and wish to comment on this application, 2026-09A, please raise your Zoom hand, which is the little hand at the bottom of your computer screen. Once you're recognized, you'll have 3 minutes in which to comment on this application. Please proceed, State Senator.
Good afternoon. Again, I'm Senator Steve Chan from Southern Brooklyn. Today we have witnessed, again, improperly filled out applications, captions left blank, exhibits improperly mixed up. There's so many questions, it's discrepancies about the application process for this development. We heard the chairman here talk about how this hearing is about whether this building permit is properly approved. But yet we heard Commissioner Yoon here talk about how we need hundreds of apartments. So going back to what I said earlier, I feel that there's nothing we can present here today that is going to make the DOB adhere to their own bylaws. And to me, that's biased. I ask that in future BSA hearings that maybe we don't talk about the reasons why these permits are needed instead of, like you said, Chairman, just whether the permit was properly approved. Thank you very much.
Next person, elected official? Any more elected officials? Anyone in the Zoom? Do you want to also speak? Councilmember Nassis, would you like to speak again?
Sorry, I wanted to state just in response, I did not say that we need hundreds of apartments. I was saying that a lot of work has been done towards obtaining that permit. That's what I said.
And all we ask is that.
I just wanted to correct what you said, because that's not what I said.
And all we ask is that.
Who wants to speak on this? Sorry.
And all we ask is that you ask the Department of Buildings to adhere to their own bylaws and their own code.
Thank you. Councilmember Narcisse. You may speak.
Hello, can you hear me?
Yes.
Okay, so thank you so much for your time, and I know it takes a long hours, and you're sitting here, and those out in the Zoom. All I'm hoping for, it's a fair share of the time that my constituent put in the time to gather all the information, and even after this, I'm hoping, and I'm always hopeful, that you can look through the process here to say moving forward. But I cannot believe that this process went like this. Like DOB did not engage with me to the process to make it easier for my constituent. I cannot believe that all the floors that attach with the beginning, I understand that you said it's not a space where we can actually talk about debate and switch and all that. But it should be relevant in making decisions because we trust people and we have laws to follow. So I'm hoping that with those laws, the thing that we highlight here this afternoon, that we can do better and engage more. And that's the message for DOB and HPD, because my constituent, I don't know if you're aware that I was in a room where I had more than 2,000 people yelling and screaming, saying that we're not following our own laws and we're not doing what we're supposed to do. If you have been in my shoes, you will know that why I'm sitting here all day, because my constituents deserve the time that they put in to the research and to understand what took place, that we don't repeat it, and I hope we can make a fair decision. At the end of the day, it's not me to make the decision, it's the board and Madam Chair. Thank you for your time, and everyone here, that we can make the constituent believe in the process and they can feel like they were heard for this process. So thank you for your time, whatever the decision we made. But I feel like the engagement was not there in the beginning to make people feel that we as government is working on their behalf and the people that's here in the panel. Thank you for your time again. Thank you.
I have to say, I do appreciate